Who is liable in a commercial accident? Person or company?
Hello and welcome to another one of our frequently asked questions. I'm Jim Adler, the Texas Hammer, and today we're talking about who is at fault in a commercial accident.
Wrecks involving large commercial vehicles like 18-wheelers, semi-tractor trailers, tankers, box trucks, and other big rigs are often catastrophic and life-changing for victims and their families. But our 18-wheeler accident lawyers know that it is not just the physical and emotional damages that are significant, but also the financial repercussions of being unable to work while having growing medical bills. Fortunately, Texas law allows victims and their families to recover compensation against a defendant in a trucking wreck for pain and suffering, medical bills, and lost wages. But one of the most common questions from victims is who could be liable in a commercial accident. At Jim Adler & Associates, our experienced and compassionate personal injury law firm can help victims and their families investigate and hold all possible defendants liable for their damages. We will work with your treating physicians and may hire leading medical and liability experts to help build and prove your case. We will not let negligent drivers, trucking carriers, maintenance companies, and other defendants hide from their responsibilities under Texas law. So, who could be liable for a commercial accident in Texas? Generally, 5 types of defendants could be liable in a commercial trucking accident in Texas. Some of the defendants are obvious, whereas others may not be obvious, but could be equally, if not more, liable for your personal injuries. Some of the most common defendants include the following. 1. The truck driver. The most obvious defendant is the truck driver or operator, and this is because the truck driver is the one at the crash scene who runs a red light, makes an improper turn, or rear-ends another motor vehicle. But while these actions are all common causes of trucking accidents, Texas law and federal regulations require truck drivers to also inspect their vehicles and their cargo before starting a delivery and at certain intervals during a delivery. The failure to conduct these inspections that result in a trucking crash could be another form of liability against the driver that is not as obvious unless you have an experienced 18-wheeler accident lawyer on your side. 2. The trucking company. Another obvious defendant is the trucking company. Like all states, Texas also has a series of vicarious liability laws. These laws make the actions of one party binding on another. One type of vicarious liability is known as respondeat superior. This involves the employee-employer relationship and holds an employer vicariously liable for the negligence of an employee while the employee was within the scope of employment. This legal principle acknowledges that the employer benefits from the employee, i.e., making money, and therefore must accept the burden, i.e., liability. But there are other ways that a trucking company could be liable to a personal injury victim. This includes hiring unqualified drivers, providing improper training or supervision, or entrusting drivers with defective equipment or vehicles. Trucking companies may also be liable for poorly inspecting their vehicles, creating unrealistic delivery schedules, or conducting negligent repairs on vehicles that cause crashes. 3. Maintenance companies. Since they could be liable for their own maintenance, many trucking companies hire maintenance and repair companies to service their fleet. When this happens, the trucking repair company and maintenance company may be liable for negligent repairs or installations, as well as for negligent or incomplete inspections. This defendant is often not obvious and more complex for a victim to discover without a competent and experienced 18-wheeler accident lawyer. 4. Cargo owner or manufacturer. It is not just the trucking company, and the maintenance company that could be liable for a trucking crash, but also the cargo owner or manufacturer. That is, the individual who provides the cargo to be shipped could also be liable in certain instances where cargo is improperly packaged for delivery, including being poorly weighted or distributed, put on inadequate pallets, or otherwise not loaded properly into a truck. This liability also includes large and oversized equipment, especially construction equipment, which is riskier to ship and deliver. The failure to prepare these items for shipping could also bring liability to the cargo owner or manufacturer. The same is true for inherently dangerous products such as fireworks, chemicals, explosives, or other objects which need to be packed and secured with care. Mistakes in that loading process could render the cargo owner or manufacturer also liable in Texas. 5. Third parties. although most trucking accidents involve some culpable conduct of the truck driver or trucking company. Sometimes third parties may also be liable for a crash. This includes other motorists that may cut off or cause a collision with a truck, or a government entity that negligently repairs, designs, or maintains a road. This type of liability can be more challenging to determine, which is why all victims and their families should seek proper legal representation.
After a commercial accident in Texas, you and your family need an experienced lawyer that you can trust to fight for your rights under the law. Our 18-wheeler accident lawyers at Jim Adler and Associates are that experienced choice that you need. We offer free consultations and only get our attorney's fees paid after we recover compensation for you in a settlement, verdict, or other award. Learn more about how we can help you by dialing 1-800-567-7575 or by reaching out to us on our website at jimadler.com.